Good afternoon and welcome. You'll see GoToWebinar's features include a questions drop-down where you can ask any questions you have during the program. We'll collect them all and answer afterward by email. Also, please note the orange arrow to the left of the control panel to minimize it, and the handout drop-down where you can download a copy of today's handout. And now we'll proceed with today's webinar. As always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution.
With that, this is Rod Max, and I want to welcome all of you to this webinar. It is a privilege for our firm to be able to sponsor these as they relate to class and mass actions. We've got a wonderful center that expands not only in the state of Florida, but beyond, doing class action and mass actions all over the United States. Today, we've got Pam Perry, Lance Harkey from our team on the screen. We also have Steve Jaffe, Terry White, a part of our team, and there are others from other states that will be joining us very shortly. I say that to say that we were really privileged, though, today to have with us Judge Lisa Walsh, Ed Zabersky, Paul Carlsgott, because they round out the opportunity to listen to their perspectives. The judge, obviously, from the judicial standpoint, Ed from the standpoint of plaintiff's counsel, and Paul from the standpoint of defense counsel. We all have a role, and we as mediators understand that role of active facilitation. So with that, we will proceed and look forward to dialoguing with all of you. With that, I'll turn it over to the panel.
Thanks, Ron. So good to see you. Thank you so much for being here. Welcome everybody to From Inception to Approval, Successfully Mediating Class and Mass Actions. We have a short period of time today, and since timing is everything, I want to first ask Judge Walsh what her thoughts are about the timing of mediation when she is presiding over class and mass actions.
It's interesting because I had some class action experience in a general civil division before I entered the complex business litigation division, and the way those are managed, at least in the old days, were very much driven by however the plaintiff was inclined to drive their case. So they were the ones who really set the pace and who governed how quickly class certification would be presented to the court. And it was unheard of for a judge to intervene and require the parties to go to mediation earlier rather than later, until before all of the discovery on class certification was complete. So now things have changed, and there's far more aggressive court management, court case management all throughout Florida, and especially so if you are lucky enough to preside in a complex business litigation division, which I am. We have different rules, and even within my own division, the practice has been, even in a garden variety case, to have two mediations, have an early mediation and then have one that's closer to the time of trial. So when it comes to class actions, after there's a reasonable amount of time to initially begin to do some of the discovery on class certification issues, on standing issues, stuff like that, I've had some unusual experiences that have taught me some of the pitfalls of asking your judge to make certain determinations before you deal with class certification or you potentially consider mediation. I'll give you an example. Sometimes the parties jointly are going to want to present an issue of law to me, an issue that goes to the substantive merit of the case, and not even the standing or the skin in the game of the particular name, the named plaintiff. I understand why that's done. If there's no substance or merit to the issue, then why have a class action at all? But it's almost like an advisory opinion, by a judge. So I do question it. And sometimes I have seen parties fall into a circumstance where The problems become apparent, the weaknesses on the standing issue become apparent, and they're so dug in that they're just not going to stop the train. And so I see value to requiring the parties to go to mediation after a legitimate, reasonable period of discovery has taken place on the issue of class certification, for example, to flesh out and deal with, especially if the case is shaky, to deal with that on the early stage rather than the late stage. And I again question getting your judge to basically give an advisory opinion to you about the merits of your case before you even deal with those issues, the standing issues, the class certification issues. So I would say that that there is merit for a judge to require for the parties to agree on going to mediation at a certain benchmark before class certification is presented for adjudication to your judge.
Very good, and thank you, Judge. As a quick point of personal privilege, in addition to being the senior judge in the Complex Business Division, you've been the president of the National Association of Women Judges and the chief of the Appellate Division. And with you in the back, I believe, is a judge from Afghanistan who is interning for you, Hilal Rahik, a judge from Afghanistan who is here with us. Judge, we're very honored to have you, and we thank you for being here as well. So thank you very much. Ed Zabriskie, in addition to serving as plaintiff's counsel in some of the nation's largest lawsuits, you've had settlements and class actions, about 70, I believe, exceeding $350 million. You've been president of the Florida Justice Association, the Academy of Trial Lawyers. What are your thoughts about the timing of when the first mediation, if there's more than one, should take place?
Well, with a lot of the comments I'm going to make today, a lot of it depends on the case. And there are some cases that are more apt to settle early. There's some cases where you can't settle them early, and you might not be able to settle them at all until you're looking at a jury trial. But I agree with the judge on one issue. I think it's a poor idea to give advisory opinions, and I think that it's tough when, first of all, as a plaintiff's lawyer, you can't bring a substantive motion before a class is certified, because you kind of lose your ability to certify a class after that point. I think it's called reverse preemption. I might be a little bit off what it's called, but I've never done it. I'm also hesitant to do it even when the defendant files a motion for summary judgment, which I see in a lot of my cases, because I'm always concerned that an appellate court is going to take a position contrary to my standing issue on whether or not my representative is appropriate. But I do agree that you need to get over the standing hurdles initially. You should know when you bring a case whether or not your client has standing. I mean, you really shouldn't bring cases from a plaintiff's perspective that A, don't have merit, and B, you don't have the proper plaintiff, because it could end in disaster for you. And just if we're giving war stories, here's mine. My trial partner, Mark Fistos and Jordan Shaw, are on the phone, and they were here, they would attest to this. We actually had a class case that started, I want to say in 1998, maybe. No, I'm sorry, 2018. And we went through judgment after we got the class certified, and the judgment was for us on the entire claim, and the defendants were going to have to pay, and they went up to the appellate court, and even though they initially removed the case from state court to federal court, claiming that the federal court had jurisdiction, and obviously standing is an issue of jurisdiction in federal courts, they decided to change their mind and to say that we never had standing in the federal courts, so the judgment should be overturned. And the appellate court agreed with them and sent us back down to state court on that case. And to make a long story short, we settled the case this year with another federal court action that we had filed in the interim. but it took us 6 years to get there, and a gigantic waste of time. So for all you plaintiffs lawyers out there, make sure you dot your I's and cross your T's that you have an appropriate plaintiff, because the worst thing that could happen to you is you go through the entire process, win, which is hard to do in a class case, and then learn that you got to go do it all over again. So those are my comments at the outset.
And thanks so much. Paul, you've defended as many class actions as almost anyone in the country. Your specialty has been data privacy breaches. You've been recognized by Chambers USA, you're a Law 360 Privacy MVP, and a National Law Journal International Cybersecurity Trailblazer. What are your feelings and experience about the timing of mediation, and what are your main considerations?
Yeah, for a defendant, the considerations tend to be a lot more practical, I think. And there are a few things that come into play. Obviously, we assess whether we think there's merit to the lawsuit, whether there are issues with either Article 3 standing in federal court or standing issues in state court. But I think from my perspective, the timing, I definitely agree with Ed that the timing depends on the case. And in some cases, the timing is right away. You know, sometimes we've mediated even before the case was filed, when we've gotten a demand letter from a plaintiff's firm that we know well. But other times, the time is once the class certification motion is pending. One thing about defendants that I think is a little bit different than most plaintiffs is that we serve a lot of different masters. We have our client, but we typically also have insurance companies that we have to deal with. And all of those decision makers require information. And so for us to decide to go to mediation, it's easy for the lawyers to agree to do it. It's much more complicated to get all of the different decision makers in line to get the authority that you need to make the decision to mediate and to get authority to settle ultimately. And so typically that will require some form of explanation, oral explanation, in addition to a written assessment of what the risks are in the case and what the value of the case is, both from a risk perspective and from a settlement perspective. And so the timing issue from a defendant often really hinges on who you're dealing with, what their risk appetite is, and what you know about what the plaintiffs are willing to do. And oftentimes that requires a lot of pre-mediation discussions between counsel. And it very much helps if you have a good rapport with your opponent and can have an open and honest dialogue about where the parties are in general in terms of what the case is worth and what the sort of the general confines of what a settlement might look like, what the structure would look like. And so I think all of those things come into play for us as defendants when we decide in terms of the time.
Ed.
Yeah, I just want to follow up on what Paul said. One of the things that he mentioned is that sometimes his clients will actually settle cases before a complaint is even filed. And that's usually when the plaintiff's counsel. And it's because in class cases, one of the things that I think is very important for plaintiff's counsel and defense counsel is you got to be honest with one another. These are gigantic cases. I mean, they're voluminous, they take a lot of time, they are for a lot of money. And it's hard sometimes for a company to admit that they're wrong, but when they're willing to admit that they're wrong, you really need two people or two sides that can work together to try to come up with a solution that's beneficial for the people who are hurt, but also beneficial for the company, because a lot of these companies, they don't want to do the wrong thing and they want to take care of their clients and the people that they've hurt, because good business is making your business go into the future. And one way to do that is you take care of the people that you hurt. So along with when you mediate comes when you're willing to have an open and honest dialogue with your opposing counsel about the pros and cons of your case. And you need to actually have an honest discussion about those pros and cons, accept what you have to accept as being a problem with your case, and the defense needs to do the same. So I'm glad you said that, Paul.
Thanks,
Oh, one
Ed.
thing I would add is that the movie Class Action is not actually about a class action. That was on one of
I've never seen it.
I had a quick follow-up.
The next slide. Go ahead, Lance.
I was just picking up on Judge Walsh's point about in the complex division having typically two mediation, scheduled in the CMO or the trial order. But in many other jurisdictions, you get a straight shot CMO that has a mediation date well near the end of the case. And then for the plaintiffs and defense counsel, nobody wants to go first and sometimes and say, hey, maybe we ought to do one earlier. Maybe we ought to do one closer to the class cert after we have some discovery on these issues. And then, so I'm just wondering how Ed and Paul, you broach the idea where you've got a trial order where mediation's, 4 years from now. What do you do when you want to get it teed up earlier?
You want to go first, Paul?
And if we could get the slide, Kathy, please. Go ahead.
Oh, yeah, I think from my perspective, it's really more a matter of getting a sense of both scope, how much the other side wants, and how creative they're willing to be in how we structure the deal. Those two things I think are the most important from my perspective, because those are the things I need to be able to educate my client on what the art of the possible is. We never have the reason we need a mediator is because we're not going to be able to come to a deal on our own. Typically, that's not always the case. But you can at least get a sense of, are we talking about a factor of 10 more than what we think the case is worth? And that's really what those initial conversations are for.
Judge, I like the idea of two mediations, but my humble suggestion to you is I would set the mediation closer to when the certification issue is going to be decided, because in a lot of cases, you really have to do some preliminary discovery in order to understand the scope of your case, what the case is really worth, and really to get an idea of the strengths and weaknesses of your case. I would also suggest that instead of having a one-day mediation, you have a two-day mediation. And the reason I think a two-day mediation helps a lot is because of what Paul discussed earlier, which is it's so important to herd his cats together and to educate him what needs to be done in order to settle a case. He has two masters. He has the client and he has the insurance company. One's paying the bills and the other one wants, closure. And sometimes it takes a cooling off period over that evening for them to have continued discussions amongst themselves to be able to come back the next day and actually get a case settled. And so my suggestion is don't force a mediation too early, but do it before certification. And I would do one after certification because, obviously certification changes the whole ball game. Once you get certified, a lot of, you're just less inclined to settle for a different structure once a class gets certified. But it's still, cases should settle. Every case should settle. Going to trial on these cases is not ideal.
Rod, you're a mediation national household word. You've done 6,000 mediations and been in best lawyers in America, more than most lawyers I know. Please give us your thoughts on that. And Kathy, if we could get the next slide, please.
Well, yeah, we'll have the slides catch up to us, but Ed and Paul, you're right on. First of all, each case has its own, and you're right. Yes, I've settled cases, class action cases in one day, but that's the minority, the small minority. Most of them are a journey. Some have lasted a year in the making or more. But typically, if you could deal with an initial stage, and again, you all heard the theme from me, nothing's agreed till everything's agreed, because this isn't about just a number, it's about the context of the number. And so identifying the pace, whether it's a marathon or a sprint, and most of these or at least a half marathon, if not a marathon. But the point is, you build up expectations by limiting it to 1 day. And therefore, if you end up or have that opportunity, let's meet. And some are, as Ed has suggested, sequential. Day 1 and day 2 back to back. And that is possible. Well, everybody's fresh, everybody's at one location. Usually they're coming from around the country. Let's all get it done. Sometimes, and deference to what Paul said, as Ed acknowledged, the different masters, both the corporation, company, and the insurer. Sometimes someone's got to go back and they need, is it a week, 2 weeks? But let's hold the process together. And in terms of a continuum, keep that ball up in the air and be ready to have that identifiable date to get back together. And it's in that regard, when we get the stress from the court, we need to report, use the mediator to simply ask for report we've met, consistent with the order, that the process is continuing, and consider this as an interim report, and we'll file a final report when we're concluded, without suggesting anything about what's going on.
Yes, Ed,
Can I give a shameless plug?
please.
Rodney is really one of the best mediators I've ever had to deal with. And it's because he is tenacious in getting a case settled.
Yeah.
Rodney will tell you, yeah, 2 mediation sessions is a good idea, but Rodney probably has 15 mediation sessions in the course of 3 months, because he's constantly calling both sides to try to continue to facilitate a settlement while we're engaged in maybe a detente on discussions of settlement. So, finding the right mediator is essential in these cases also. Someone who's just bringing numbers back and forth, they're not going to get your case done. But getting someone who's highly skilled, like Rodney, like Lance, like Jaffe, involved is really something that you need to consider. And Judge, I guess another humble suggestion is maybe you suggest the mediator, because there's only a handful of folks that I would actually trust to mediate any of my class cases.
And mediation really is a process, not a session. And I appreciate that you refer to non-conference communications as sessions. That's part of it. And I think preparation really does make perfect. How often do you get on the phone or on Zoom with your mediator, and how often do you do it with your mediator and perhaps the other side, almost adversaries working in a collaborative way to move forward? And what do you talk about when you do that? Anybody? Rod?
Well, I'll just say it is my normal course that when I get a mediation confirmed for a date, especially class actions, when it's a case that's not a non-class action, 2 weeks out is fine. But when it's a class action, you need a month, maybe even 6 weeks to try to do that if you have that time. But meeting privately by phone, sometimes Zoom, on the plaintiff side, meeting privately, confidentially with the defense side, and then finding, who are the leaders? And in a group of plaintiff lawyers, and they may come from a number of different states, there's going to be some leadership. And what can we do? What can I do as the facilitator to actively perhaps even suggest, let's get an Ed Zabersky together with a Paul Carlscott, and let's talk before we get there to lay out the agenda of what we anticipate accomplishing, the pace of it. That pre-mediation is critical. And it may end up being more than one plaintiff session and more than one defense session. And maybe on Paul's side, we've got to incorporate the insurers. And maybe on Ed's side, there are times, I'm smiling because I had one of late, when even the plaintiffs themselves may need to be incorporated because of their expectations of the process. But certainly among the lawyers, that is necessary. You need to have an agenda. Are we going to be talking substantively about issues that are otherwise motion to dismiss or certificate, or are we going to talk structure? And of course, we're always trying to trend towards structure because that's the mechanism to try to resolve it. Nothing agreed till everything's agreed. That's what I say from the mediator standpoint. Ed, your thoughts on it?
Yeah, my thoughts are similar to yours, Rod. I think that pre-mediation communication is essential in these cases. It goes back to what Paul and I discussed earlier, which is, trust and camaraderie between the lawyers is also very important. I believe that you need to have at least one session with each side individually. And I honestly believe that you need to have a joint session with a preconceived checklist similar to one I'm holding up here, where you try to narrow the issues as much as possible even before you go into mediation. Things like the class definition, things like the scope of a release. I mean, I know that Pam, you wanted to talk about a whole bunch of these things as we go on, but there's a list of things that you have to deal with in a mediation or a settlement of a class case, and most of them aren't going to be terribly controversial, but it's nice to get them all out of the way before you go in to the mediation and you're actually arguing over nuts and bolts. How much is going to be paid? How is it going to be paid? In what manner is it going to be paid? You're going to talk about fees and costs. Those are usually the things that need to take up a lot of time, and it's better to get some of the other stuff that's easier to resolve out of the way before you even walk into the mediation session.
Agreed. And Kathy, if you're there, if you could move the slides forward, please.
Yeah, one other thing I want to add, Rodney, you said sometimes you have plaintiffs' lawyers that are in competing camps. For the lawyers out there that have that, the plaintiffs' lawyers, you have two lawyers that file the same case. You got to come together and you got to have a discussion about how you're going to divide up the case. I've had situations where we've done it nicely, and we've had situations where it hasn't been done nicely. And my humble suggestion to all plaintiffs' lawyers out there that have this situation is, if you have plaintiffs' lawyers on the same side as you but competing, get on a plane and go visit them face to face and settle your differences before the mediation session, because it works.
Yeah, and along those lines, what I would say on the defense side is that especially when there's an insurance company involved, having pre-mediation discussions on the defense side collectively to get everyone on the same page is essential, if possible. The worst outcomes I've ever seen in mediations for defendants, and what I mean is the biggest settlements, so the best ones for plaintiffs, tend to be ones where the plaintiff and the mediator are successful in pitting the defendant against its insurer. And so if that can be avoided, the defendant and the insurer collectively will get to a better deal, almost without exception. And so one of the things that I do in preparation for mediation, in addition to all the things that Rod and Ed talked about, is make sure that I have a series of discussions with both the insurer and with the defendant, separately and collectively, to get them on the same page.
Very good. Lance, any thoughts? Mediator?
I think both Ed and Paul are dead on. Unfortunately, sometimes, when you have multiple cases filed as plaintiff's counsel, you may have a situation where one plaintiff's counsel and the defendant choose to mediate in a particular forum, and the mediator may not even be aware of the context necessarily of the overall context of the litigation nationally, and like Ed says, the best way to hit that head on is to find out who's in charge and who should be in charge, who are the people on these 7 filings that I've just seen, and how do we get together before it goes down a wrong path.
Very good. In terms of talking about templates or materials that can be used within the mediation, is that something that you put together before the session from time to time?
Pam, you were reading my mind, because part of the pre-mediation is evolving that term sheet. Now, sometimes you need to be at the table to do that. And the question is, how far do you go? But these are not just like any other case. And because of the number of issues, from definition, scope, notice, admin, monetary remedies, non-monetary remedies, but for the 11th Circuit right now, incentive awards and attorney fees, all those have a sequence to them, but they're part of an agenda. And the more that can be synergized in pre-mediation to come with to that mediation, some could be, hey, let's not waste our time on definition. We've agreed on it. Bingo. How about notice? Not a problem. But when you get into various aspects, sometimes administrator is an issue. Sometimes there's competing desires to have different kinds of administrators. Sometimes now we can get beyond that. Let's get to the remedies. I typically, when you have monetary and non-monetary, which go first? I, as a mediator, am looking for synergy. And if something can create synergy, numbers, money, it has you at least to begin with differences. But the terms, the non-monetary aspects of those terms, those could bring people together to create. We're trying to build trust. Trust is the ultimate key. When you have people like Ed and Paul involved, where there's a natural trust, having dealt with so many cases together, but sometimes the attorneys are unknown to one another, and we've got to grow that trust. Well, pick the points that'll help grow that trust, and then evolve into those things that are the key, the money, the incentive awards, the fees that end up being done as we work through it. Ed, Paul, do you see doing that ahead of time in terms of trying to create that agenda, if not just the term sheet?
You got to do it ahead of time. Otherwise, you're wasting your time at the mediation on the issues that are ultimately going to make a decision on whether or not the case settles or not. And that goes along with the check sheet that I talked about. I mean, look, class definition is usually pretty simple, and you have a class period. You go back your statute of limitations until the date of the settlement. If the defendant wants something different, you listen to him. If you think it's reasonable, you say yes. But those types of things, they need to get, if you're discussing those things at the mediation, you're not going to settle.
Right.
And Paul, but from your standpoint, having the plaintiff's counsel provide that to you, allow you to kind of put down what you need for your people. Is that right?
That's right. But in some situations, we provide it ourselves. We make the first move in terms of here's our structure, because from a defendant's perspective, structure can be very important. So the decision between a claims made and a common fund, there's no secret the defendants prefer claims made settlements because a common fund is simply 3 or 4 times the attorney's fees, and that makes the settlement excessively expensive in a lot of cases. And so one of the things that we need to work through early is there a way to do a claims made or some kind of a hybrid structure for the settlement that provides for some relief to the defendant in terms of what it has to pay overall, and what the plaintiffs, and I'm not going to hide the bias here, but what the plaintiffs' lawyers need in fees to get rid of the case. And so, and then also, obviously, there's a portion of that involves what the judge is going to approve. So, the judge is going to have something to say about the terms at the end of the day, and you have to have a discussion about that. The only thing I would add is sometimes it is helpful to have some of these issues kind of held back to discuss, because in some mediations, especially when the parties are far apart, it gives you something to talk about and keep the momentum going. And so having some details to go through in some cases can be helpful.
Okay, let's talk about the day of the mediation session. Let's talk first about who should attend. Lance, what are your thoughts about that?
Well, I mean, as a mediator, you want the people who are the decision makers. One of the things that I noted, I found very interesting, I don't know if you guys saw that Judge Rogers in the 3M case recently ordered the parties back to mediation, and Paul insisted that the CEO of 3M personally attend, and as well as the entire plaintiffs committee, and not just the settlement committee or the leadership or the lead counsel. So I thought that was very interesting. So you know, you have to have the right people. Sometimes you have insurance companies, sometimes that you can have multiple defendants who are mediating, you know, separately among themselves over allocation issues. So yeah, you have to have the right people involved.
Rod, thoughts?
Yeah, first of all, it's indispensable, both on the plaintiff side and the defense side, that your authorities got to be there. And you've got to sort all that out in pre-mediation, but on the day of mediation, and the sensitivities are between the company and its insurers. Let's make sure we've got all the insurers that are necessary. Now, if you've got $100 million worth of insurance and the case is worth 50, you don't need those that are over that, other than that which is over that are looking for the ability to get this case done below them. But the point is, you've got to have all of those people there, and that becomes the responsibility of the defense lawyer. The defense lawyer needs the feedback from the plaintiff's counsel to understand the need to bring those people there. Now, the court issues orders by way of, you know, all the parties, participants, and their insurers and officers, directors to be there. But, you know, it can be pared down to the right people. On the plaintiff side, what's interesting and somewhat ironic, I mean, we can request the class representatives to be there. And there are times that sometimes they want to be there. At the same time, pragmatically, the idea of these plaintiffs and being there is really not as necessary as you would generally think. And that's not to say it's one way for the defense and not for the plaintiffs. It's just something that is understood among counsel. This is controlled by the attorneys on the plaintiff side, and therefore how indispensable are those parties. I've had some where some of these plaintiffs are very, very interested and want to be involved. And then you have to take the time, and it does take time to educate them through the process. That's why if it's not necessary, maybe even it can be covered through pre-mediation, that day you don't need them. But you absolutely need all plaintiffs' attorneys and their leadership. You need all defense counsel, their leadership, their company, people that can make a decision, and their insurers. And sometimes those may be competing, as Paul well knows, because we get called either into breakout rooms or into the hallway to talk about the issues that may be between the company and the insurer when there are coverage issues, for which there may be a need to have a coverage counsel there to deal with. So there's a lot of dynamics to the right people being there.
Judge, do you ever have people before you insisting that people with higher authority or more authority attend mediations? Has that ever come before you?
It's typical.
Typical?
Yeah, it's typical to require that. Otherwise, it's you know, there's someone there who says, well, I have to, you know, go back and, you know, and see whether I have the authority to do this or that, and it ends up wasting people's time.
And have you had lawyers before you complaining that someone with proper authority didn't come up? I think every mediator in the country has come up against the authority issue. Do you ever have lawyers before you complaining about someone with the proper authority not attending?
I'm sure it's happened. I mean, I can't think of a time recently, but it's understood that there needs to be, otherwise it's, you know, it's theater, right? And not a real process if you are not able to get guidance on the parameters of the, you know, of the authority of the folks that are there. So I'm sure it's happened. It's just, it doesn't happen frequently.
Yes.
I would say pre-COVID, you know, I don't know if Ed's had this experience, but pre-COVID, there were situations where, you know, the defendants would insist that the class rep physically be present at a mediation for, you know, whatever reason. Ed, have you had that experience?
Sure. A lot of times the defendants want to make our lives difficult and make
you
the
sit all day
plaintiff's
with-
lives difficult, and they require the person to come. And sometimes if they can come, I ask them to come. I always give them the choice to come, but I don't think it's essential that they come. And sometimes they can be available via phone, because we're going to be discussing a lot of things that they're not really going to understand, and it's not fair for them to take off from work for an entire day. So always invite them, but they shouldn't have to come. And quite frankly, if a defendant doesn't care enough about the case to send someone with authority, that's okay too. I mean, some cases have to get tried, and I think it's a bad idea for a defendant not to take any of these cases seriously because there's so much money involved, but sometimes they don't, and then they have to learn the hard way by not settling it and then realizing on the courthouse steps, we really don't want to go to trial on this. And then sometimes it'll cost them 2 or 3 times the amount that it would cost them if they would have settled at a reasonable time. So
It's a huge education process, and for someone not to take advantage of really hearing what the case is about, if not before, which they should during, doesn't make a lot of sense.
it goes back to having professionals on both sides, because a professional lawyer, defense lawyer, is going to make sure that the right people are at that mediation and are well educated on the issues of the case and the pros and cons of resolving the case early. So that's Paul's job, and I know he does it well, because I'm listening to him, and the breadth of what he's talking about is really incredible. I mean, in some ways, he's got a harder job than me.
Well, the way I would put it is the mediation process is there to allow both parties to get as much information as possible to know what their options are. And so if you're playing games with the process, you're not getting that. And so, and when I have an issue with authority, it's a real issue. It's not a gamesmanship kind of ploy. And also, if there's a situation, and it's been very rare where I've demanded that a plaintiff attend, it's usually because I have some distrust that the lawyers have adequately conveyed a prior offer to the plaintiff individually that might cause the plaintiff to settle. But in most cases, neither of those things become an issue. I've really never understood when you get an order that says you must have people with full settlement authority. I don't really know what that means. If it means, the ability to pay whatever it is the plaintiff demands, I don't really take it that way. I tend to say, someone who has reasonable authority to settle the case on a reasonable basis based on our advice. And so that's usually how we do it. And if you've got someone that you've developed a trust with, both the opposing lawyer and the mediator, that tends not to be an issue. So I think those things are all things that can be avoided and should be avoided if you want the process to work the way it's supposed to.
Judge, can you comment on that?
Judge, how would you deal with that in terms of extent of authority?
Well, it depends on what kinds of cases. Not specifically with respect to class action cases, but I have had, the reason those orders are entered is, I have had bad faith mediations where, someone went in and said, I have the authority to settle for $1. So, there's a reason why the language says what it says. But this is extremely valuable to me, Paul, to listen to your input on that, and maybe the order should be tweaked in a particular way. I would also point out that most, if you're in state court, again, I'm not a federal practitioner. If you're in state court, and not most, but a healthy number of circuits in this state and in many other states, they have either chancery court or they have complex business court, and you have a lot of power in the way the judge's order is ultimately going to read, because you are the ones who are submitting to the court a joint case management schedule or joint proposed orders that you can incorporate a lot of this into it and make your lives a lot easier along the way.
And
one thing I do want to bring up, and it's something that I think we all should consider, is sometimes we go to mediation with our client and we find that the defendant offers our client 50 times what their case is worth in an individual settlement. And they try to pick off our class rep and pay him off essentially. And plaintiffs' lawyers, you need to be careful of that, because you owe a duty to the class, even though the class isn't certified. And a well-known lawyer actually lost his bar license when he went ahead and he settled the case on an individual basis.
Right.
So I say that for a number of reasons. First of all, when a defense lawyer comes out with an individual client that's 50 times what they deserve, I leave.
It's like Ed may have gotten frozen.
Storming in Miami.
He stormed out of the room.
Yeah, it's very important what he's saying, so we get him back.
Is that there are folks out there that do, and it's just something that I think plaintiffs' lawyers need to be careful of.
Okay, and Ed, we had a slight glitch on your audio. I think the storm was.
Pam, if I could pick up on what Ed was saying for a second. Paul, is there, during the course of a mediation, would you feel it appropriate to attempt to, move towards an individual resolution versus, there's always a question during the course of negotiations, from plaintiff's lawyers' perspectives, from defense lawyers' perspective, do you extend it, when do you extend it, you do it after class settlements have failed or before, what are your thoughts on that?
Well, I think that it's sort of rare these days, especially based on the way the law has developed on, the ability to pick off plaintiffs and the mootness issue. That was kind of a in vogue tactic maybe 5 or 6 years ago. It's less common now. I think the situation where it would come to play is if you're in a situation where you think that the lawyer's unreasonable demands for fees is what's holding up a deal. That really depends on the situation, and it requires help from the mediator to understand that that's the dynamic. And a lot of times when you're negotiating, especially, and I talked about earlier, the common fund versus claims made, typically when you're negotiating a claims made settlement, you can't talk about fees until you've reached an agreement on all the terms. And so you're essentially having to divine what the plaintiffs are looking for in terms of fee by proxy, figuring out what terms they're demanding and that kind of thing. And so all of those things may come into play. I think it's much more rare these days to try the pick-off tactic. It's just something that hasn't been successful. Hopefully Ed will come back, because I'm very I'm always very. Oh, he's here. Okay. I'm always intrigued, and this is something I don't envy plaintiffs lawyers for, that dynamic between, owing a duty to your client to convey a settlement offer, and what you're talking about is the duty to the typically as yet uncertified class, and how you navigate that.
Well, it's a great question. I'll give you a war story. So I had a class case where my class plaintiff was entitled to $1,000. And the offer initially, they didn't want to settle the case as a class. They offered $50,000 for my client. And my client wanted to take it. And I looked at him and I said, I can't be your lawyer anymore, because I'm not going to go in there and accept this offer on your behalf, and I'm going to withdraw as your counsel. If you want to go settle your case, you can, but that's up to you. I don't want any part of it. Eventually, he was no longer the class rep. We had to move to intervene, which was objected to by the defendant, and the court let us intervene, and we went on with the case, but it delayed the case about 6 months because of what I call, well, it doesn't matter what I call it, but it was what it was, and it does happen, and it's just something that unfortunately, delays the process, and I don't think is a great look for lawyers. And I would hope that plaintiffs' lawyers don't take that and then take a fee on it, because it's wrong. When you file a class case, you're filing it as a class case, not as an individual case to make a couple of bucks.
And some of that can be pared out in pre-mediation to deal with that before you get on the screen. And when you're on the screen, you got all the clients there to get bogged down in issues like that. It is not helpful. On the same time, sometimes it's requested where, you know, we just want them there and we'll talk at the mediation. So it is a very sensitive subject, and one that has got to be treated with professional sensitivity in terms of where that goes.
And a good subject to speak with the mediator separately and then perhaps jointly if necessary.
And if the mediator has a good relationship with counsel, you know, in the claims made context that Paul just mentioned, you know, the mediator will have a feel and be able to understand what the fee, you know, is, where it's heading when you reach there.
Of the conversation during the mediation as well. Let's talk about, I don't want to run out of time, just real quick, and incentive awards. There's long history going back, I think, to the 1800s. Lance, you want to just touch on that quickly?
Well, I mean, let's ask the practitioners. Ed, what do you do with incentive awards nowadays in the 11th Circuit? I don't think
it's a complicated issue, and there are folks out there that believe that in cases involving diversity, you can get an incentive award, and in cases involving a federal question, you can't. I don't really ascribe to that school of thought. I think that incentive awards in federal court are non-existent. I don't think it makes sense in the 11th Circuit to ask a judge to commit what might be reversible errors, so I don't ask for them. In state court, I do. So that's my feeling. I know that a lot of people disagree with me, but, you know, again, you only can lie to a judge once, right?
Yep.
I have seen a few situations where the parties have, you know, held an award in abeyance pending, you know, further, you know, revision by the 11th or the Supremes.
That could happen. I mean, the Supremes didn't take the case up, so I'm not so sure that they're willing to change the law. And again, maybe we need a clarification. But look, I think it's a terrible, terrible thing. I mean, it's just a disincentive to people to get involved in these class cases. We have some cases where folks sit for a day-long deposition. They have to do a lot of work. They got to come to a mediation, and to get no money for it is unfair, and we can't pay them. So we can pay their costs, but that's it. And I think it's just a real disincentive to folks getting involved.
Folks, we're going to be coming in a few minutes to the end. I was hoping we could talk briefly about, and I'd like to start with Judge Walsh. In terms of approval, what would you like to see? What would you like to not see? The goal of this whole process is to get your approval. So we wanted your thoughts.
I mean, a fair process, you know, I think is and a streamlined, easy to administer process so that I can close and end judicial labor in an efficient manner.
Very good.
I'm also curious from the judge's perspective on how important it is, and oftentimes we hear from plaintiffs at counsel that they want to mediate, even though we probably could get to a deal between lawyers, but they want a mediator for cover. I wonder how important that really is to judges.
Whatever gets us to, you know, to the finish line is what's important to judges. Sometimes attorneys will say to me, we know what we're doing, we don't need a mediator, and they're often wrong. You know, I don't know that I would call it cover, but sometimes you don't know what, you know, you're very experienced at what you do. You know, everyone who's on here is a veteran in this process, but not everyone is. Even some of the folks who are handling class actions in my division are not experienced at handling class actions or at mediating class actions. So they may not truly understand or appreciate all the ins and outs. And I think generally judges would prefer to have a mediation.
You know, in more than one class action that I've done, I've been requested to appear before the judge, releasing confidentiality and explaining not the terms, but the process. And sometimes that's done because there's the concept of objectors. Objectors may be there wanting to see if there's something about the process that wasn't, quote, arm's length. And yet, and so there have been times, I'm not saying a lot, but here, half a dozen or more times when the mediator's been asked to, it's standard to give a declaration. You know, hopefully that gets it done. You don't have to worry about appearance, but there are times that that may be necessary and is done.
That's interesting.
And folks, it's 12:55. I believe that that is our cutoff time. Unless I'm told otherwise, I cannot thank you enough for this just absolutely outstanding panel, leading plaintiff, defense lawyer, senior judge in the complex business division, Rod Max, the premier mediator in the area in the country, Lance Harkey, and if I fail to mention it, Lance practiced in this area for years and years. He's one of those rare scholars who turned his attention to mediation, and we are so grateful. Thank you so much for being with us. If there's a mechanism for questions, we'll be happy to take a look at them, and if we can't handle them now, we'll be happy to
We'll respond afterwards.
Be happy to respond afterwards. Thank you so much. Thank you to our participants. Thank you to the audience for being here from inception to approval, successfully mediating class and mass actions. And I wish everybody a wonderful day and look forward to hearing from you.
Thank you.
Thank you.
If you are a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 230-4747, N as in Nancy. Attorneys in other states will want to check for our follow-up email on Saturday. It will provide details on obtaining continuing legal education credit in Alabama, California, Georgia, Illinois, New Jersey, New York, and Texas. We are building our webinar schedule for the remainder of 2023. Please watch your email inbox for news about our future programs. On this slide, you'll see contact information for our presenters and technical assistants. Thank you, everyone.
Thank you.
Bye, everybody.
Thank you, everyone.
Appreciate
Thank you
it.
so much.
Take care.
Bye.